market has a lot of our attention and a lot of our bandwidth, because we feel that there is a huge opportunity there. There are numerous initiatives that we can take, and when I say bond market, I include hybrids also. So the bonds, REITs and InvITs, this is an area that we feel is relatively underdeveloped in our country and certainly needs a lot more of our attention. And so one of the first things that you are seeing as a manifestation of that focus on these markets is the online bond platform. And I think what is important here is that the objective here is to facilitate retail participation in this entire mechanism. So earlier, the face value of listed privately placed debt securities was 10 lakhs. We are bringing it down to 1 lakh straight away. And we have also communicated to the industry that we are open after a certain period of observation of how this framework works to perhaps bring it down even further, because the objective is really to assist the retail investor to come into the bond market and actively participate. So that's really about the online bond platform. The second is in terms of the key performance indicators and the disclosure requirements for IPOs. I think many of you are aware of this issue, particularly for the companies which are so-called new tech companies and are loss-making entities. As we know, for them, the traditional financial parameters are not really meaningful, and in terms of assessing what is the valuation, what is a fair price, those metrics, normal classical way is not appropriate. And therefore, it was considered that for the investor to truly invest while being an informed investor, the additional information that he needs is really the KPIs or the key performance indicators of these entities. Naturally, these KPIs would be different for different companies in terms of the kind of business models that they follow, but the working hypothesis here is that the indicators that the company has itself internally been monitoring, as well as sharing with their early private equity investors, or the parameters that they have been sharing as part of their early marketing to the QIBs, etc. Those are the parameters that would be relevant equally for the retail investor to know and to be able to appreciate. And naturally, the linkage of all this is to the share price, what is the value at which the shares are being offered, and therefore also a comparison between the more recent transactions that the company has done in terms of placement of equity and what is it that is the price at the time of the IPO. So, to reiterate, what is the purpose and thinking behind this disclosure requirement is really to give investors a better basis to make their decisions on whether the price is right for them or not, and also to share what is it that has been, there should be no information asymmetry. So whatever it is that has been shared with the QIBs, it's what should be shared with the retail investors. But of course, with one important caveat, which is that, as you know, in our offer documents, we don't permit any forward-looking statements. So therefore, the emphasis is on disclosure of the past, and then, you know, the investor really makes what we believe is an informed decision. The third is in terms of an amendment to mutual fund regulations. This is more procedural, really meant to ensure that when you and I redeem our mutual funds, we get the money as soon as possible. The old regulations were drafted at a time when checks had to be issued and all that, so obviously that is very anachronistic today. The payment systems in the country are so fantastic today that there is absolutely no need for any delay or any time requirement for making sure that the investor gets his redemption money and his dividend as soon as possible. So that is what has been done. The next one is in terms of net settlement of cash and F&O. Perhaps I think people who operate in the stock market will rejoice at this. The implications are quite significant. In terms of earlier, as you know, it was a sequential settlement which required the investor to bring in separately his commitments for each transaction. So in the cash equity segment, he has to bring in the money separately, and for the F&O, he had to bring in money separately, and the two were not netted. So this we found was not really required from a risk management perspective, and therefore any entities who are permitted to, which are not mandatorily required to take physical delivery of shares, all such entities, which of course covers all the retail investors, will be permitted to do net settlement, and this would make the entire process much more efficient, and the amount of fund flow, the cash that an investor will have to bring in to settle his trades, can come down very significantly depending on his positions. The next one is about pre-filing of an offer document. This is also very much a liberalization and a flexibility being given to the market. It is not mandatory. It is an option. You can continue to follow the IPO document filing process the way it is today. But if you feel that you're not quite sure that you actually want to go ahead with an IPO, also in terms of market timing, you're not quite sure when you may want to come with the IPO, you can do a confidential filing. This is what it is referred to in other jurisdictions. You can do a confidential filing. So the market knows that an application has been made, but the document itself, the detailed document, is not in public domain. It is confidentially filed with the exchanges and Sebi. So that period when Sebi and the exchanges are examining the document before giving observations, it is held confidential. After Sebi has fully examined and given its observations, at that time, depending on when the issuer wishes to actually launch his IPO, he can then file the document and make it public. So this takes care of two things. To our minds, it's a good proposal because it addresses two wonderful things. One is it gives flexibility to the issuer that if there is confidential information in his document, it does not become public until he is sure that he actually wants to go for an IPO. And secondly, from the investor's perspective, the document that is then available for 21 days has at least the first set of Sebi observations already incorporated in it, which today actually is only a 5-day period, because initially 21 days, then 5 days with Sebi observations. So now the market will have that benefit as well. So net, we felt it was a win-win for everybody, and it's, as I said, optional. So it's up to the offerers, the issuers, what is it that they would like to do. The next one is in terms of appointment and removal of independent directors. Again, this is a liberalization initiative. It gives flexibility to the companies. You can follow the current regulation. You also have an option. The current regulation says special resolution. But if you don't want that and you want a majority of minority, we are perfectly happy with that as well, because it gives even more power in the hands of public shareholders. So this option is now going to be available both for appointment and removal of the independent directors. Separately for reappointment, there are some other constraints. We are working on those constraints, but right now, at least for the first stage, this is optional facility given. So it's also in the nature of a liberalization. The next one is in relation to real estate REITs. This is also liberalization. So you're going to hear a lot of liberalization. I think I had mentioned in one of my interactions that in Sebi we have created within every policy cell at least one and often up to 3 people whose only KRAs for the year are developmental and liberalization activities. So I think you're starting to see the first manifestation of the structural change within Sebi. So a lot of focus is being given on we need to do things which are developmental, which are give flexibility to the markets and empower the markets much more. So the REIT regulations are being changed so that the minimum holding by sponsors now is required to be less, reduced from 25% to 15%. This is in line with InvITs. and you know, a progressive step in that sense. The next one is in terms of InvITs, where there was a separate regulatory framework for unlisted private InvITs. This henceforth will now be discontinued. The purpose behind this is that the kind of, since we are essentially a disclosure-driven regime, this particular regulation did not have the facilitation for public disclosure in many ways, so it was perhaps not appropriate, and therefore going forward this separate framework for private unlisted InvITs will not be there anymore. So you will either have a public listed or a private list. And as I said, to reiterate, the purpose is to ensure that disclosures are there for all kinds of InvITs. The next one is on AIF regulations, and this is really to bring a certain amount of certainty into when an AIF scheme will mature. So currently the way that the regulations are, the private placement memorandum says that the scheme will be for a period of, let's say, 5 years, 7 years, 10 years from final close. But there's no certainty on final close. So the thought was that it needs to be defined from first close. You can then define whatever you like. As you know, Sebi regulation puts no bar. There is no bar on the tenure that is there for the AIF. They can say 5 years, they can say 10 years. Extensions, of course, are limited by another 2 years. But the important thing is there must be certainty for an investor when he puts his money in. He should know when to expect his money back, which under the current regulation was not facilitated. It could have become anything. So the objective is to bring certainty into that. And also there was a requirement to bring in some changes in terms of our regulation when there is a change in manager or sponsor, because that is quite a significant change in the AIF, because if a scheme is managed by a new entity as a manager or a sponsor, then it's a very significant change and would require SEBI approval and also some additional requirements. The offer for sale, this is another liberalization measure. Here what it is that non-promoter shareholders, even though they may have 25 crores and above of shares that they want to offer for sale, there was a restriction that unless that constituted at least 10% of the share capital, they couldn't come under this window. So it was highly restrictive. So we have now removed that 10% altogether. We are saying it is not relevant. What is important is that 25 crore number. So any investor, including FPIs, including other domestic institutions, if you wish to avail of the OFS mechanism, you are free to come, so long as the 25 crore number is there and you don't need to be holding as much as 10%. Also, there were restrictions on how frequently you could do this and what is the cooling off period between transactions, buy, sell, etc. This was a uniform plus minus 12 weeks. We believe that progressively SEBI will look at regulation in a segmented way and a risk adjusted way. So you don't have to apply the least common denominator or the highest common factor to every entity in the market. Risks are different, and in this case, since the key risk arises from in case there is not enough liquidity in the market, so we have segmented all the companies into shares that are highly liquid, liquid and not so liquid, and the requirement of the cooling off period therefore has been drastically reduced to only plus minus 2 weeks for the highly liquid, and I think 4 weeks, I've forgotten now, what did we say, 4 weeks for the middle category, and of course the illiquid stocks continue at plus minus 12 weeks. Also, up until now, OFS mechanism was not available for REITs and InvITs. We have now enabled that for REITs and InvITs as well. So one more class of asset will now be available for this. So the objective here was much more flexibility, segmented approach to regulation, don't have to apply one size fits all rules to everybody. it is risk-based. If there is lower risk, we should be more flexible. If there is higher risk, we need to have tighter regulations. That is the whole philosophy which is reflected in this particular regulation change. Next one is on monitoring of utilization of proceeds from QIPs. This is simply an extension. As you know, the credit rating agencies are required to monitor the utilization of proceeds from IPOs. It is now being extended for QIP placements. Nothing very significant in this. The qualifying issuers are the same, 100 crores, etc., etc. Not much difference in that. Next one is in terms of schemes of arrangement. As you know, when companies go for a scheme of arrangement, if they are equity listed, they come to us for our observations, comments, approvals. If they are only debt listed, means they don't have listed equity but only listed debt, up until now they were not required to come, and there was a lot of confusion in the market because some of them were coming, some were not coming. It was not clear to people what exactly the regulation said. So we are bringing complete clarity, saying that yes, it is required, and it is on the same basis and following the same process that is there for the equities, listed equities. Then we move on to which one did I finish? 30. Okay. So in the takeover regulations, we had been approached by the government to say that when there is a strategic divestment of PSUs, the process that the government has to follow is a much more transparent and a much longer process than what happens when there is a private entity and a promoter divesting a private entity. On account of that, what happens is it gives the market an opportunity to pump up the price of that stock and makes it very difficult now for the acquirer to actually make an open offer with a pumped up price, and therefore recognizing, so this is again consistent with our approach of a segmented approach. So we believe that yes, the open offer process is distinctly different for PSUs and distinctly different for private entities, and therefore this flexibility needs to be given for the public sector, where the volume weighted average market price for that 60 days trading days, that criteria for pricing must go, because it can and it is vulnerable to be a manipulated price. So we are removing that criteria because it is not relevant given the process that the Government of India follows for strategic divestment. Next one is about inclusion of units of mutual funds under prohibition of insider trading. There was a certain ambiguity in our regulation about what is the way in which this is to be done, and we felt that given that this is now a very large asset class, a very significant amount of investor money is in this segment, it needs to be, all ambiguity needs to be removed, if any. We did not believe there was ambiguity, but the market felt there was ambiguity, so we felt that we needed to ensure that the market did not see any ambiguity in this, and therefore we have done this. But the nature of mutual funds being very different from listed entities, we have chosen to have a new chapter for this, so that all the definitions and all the processes are very clear and clearly defined, so that again there's no ambiguity in what is required if it's a listed entity, what is required if it is a mutual fund. It's a separate chapter under Prohibition of Insider Trading Regulations. So in short, the purpose is to bring complete clarity on what constitutes insider trading in relation to mutual funds. Last one is really something that we hope will never happen, but in case it does, so it is merely a facilitation in law to ensure that there is a framework available with every clearing corporation as to, in the event that a winding down needs to be done, what is the method by which that will happen. Over to you. We'll take questions.
Yeah, please. Good evening, ma'am. Just one question as far as the board meeting and the agenda is concerned, and the second one out of the board meeting agenda. There was also a proposal which was in discussion by the board when it came to cutting down timelines for buyback and open offer. What has been the stance on that one? Where does the discussion lie? And as far as the point outside the board meeting is concerned, you happened to mention very recently that you're looking at implementing the rule as the sort of mechanism on the secondary market side as well. How soon could that happen? What's the way forward as far as that particular thing is concerned?
So, ASBA, like for secondary market, is very much under discussion, but it is, as you can imagine, operationally complex, and therefore a lot of the devil lies in the detail, and we want to be absolutely sure that that process can happen seamlessly. So it is still with the working group, with all the stakeholders, and they're making pretty good progress. We will make progress on that, but it was not yet ready and baked for a board approval at this stage.
Okay. And the second one on the timelines for buyback and open offer?
Yeah, both takeover code and buyback, we are under deliberation now, work in progress. Both the regulations are in the process of being changed in terms of timelines and other aspects of it.
Is it closer to finalization, or in terms of regulations? Or
Not closer to finalization, take some time.
Again, I think this is, directionally the intention is to move in that direction, because given what technology can do and given what the existing infrastructure in the markets is available now to do, directionally we are moving in that direction. But operational things really have to be worked out, and that we need to give the time to the working groups to work out operational details. Until then, one should not just announce something unless it's clear as to how it will operate.
Ankur Mishra from ET Now and ET Now Swadesh. Ma'am, my question is regarding 13 point where takeover regulation amendment is there. You also mentioned that bank guarantee also needs to be given. I wanted to know what is the objective behind that.
So, actually quite simple. We consider a bank guarantee equivalent to cash. So the regulation says that even before the entire open offer, etc. process is complete, if you wish to take over the company and start running it, we don't have any problem. But you put the entire amount, assuming full open offer, is taken up. You put that money in cash in an escrow account. Now, what has come before us is that a bank guarantee is equivalent to cash. So you allow us to give you a bank guarantee in place of cash. So we think that there is no challenge in this, but naturally, the banking regulator has certain norms regarding capital market exposure, regarding purchase of shares, funding of acquisitions, etc. So the facility of being able to furnish bank guarantee instead of cash will be subject to the banking regulator. But from our side, we treat the two as same.
Ma'am, also recently you had mentioned that you are not against algo trading, but and there is direction also which was issued to the exchange to form the regulation, and whereby it was also mandated you cannot have any past returns or future returns like if we discussed. I want to ask, in future, when first of all, is there going to be any revised regulation which is coming from regulator after exchanges form something? And second, in terms of disclosures also, you have repeatedly mentioned that they are important. So once this formulation happens, will you allow based on the parameters which it can be proved, will that be allowed in future? Yeah.
So the short answer is yes. What I would want to elaborate is that the attempt was already made by us because we issued a consultation paper in this regard. We expressed in the consultation paper willingness and openness to do that. And in fact, for many months after that, we kept the dialogue on with the industry of asking them to help us understand how this can be proved. The claims can be demonstrated, proved, simulated, whatever it is that they are saying. And they reached a point where they were unable to do so. And therefore, it was, in fact, I would say, we unhappily decided to break up our circular into two parts. The first was to ensure that on an ongoing basis, the mis-selling that was happening in the market should stop. And secondly, as and when the industry was ready to come back and show us and demonstrate that their track record can be, the claimed track record can be audited, simulated and proven, we would very, very happily consider it and look at it going forward. So, in fact, we worked very hard to even do it in the first phase, but the industry, I think, was not ready. And so we had no option but to break it up into two parts. I would like to say that in all of these things, we consider the marketplace as our partners. If they thrive, we thrive. If they fail, we fail. So it distresses us a lot if market participants fail or do nasty things in the market. It is very sad for us because in effect they are our family, they are our partners, right? They are in our market. So it is very important for us to ensure that our partners in our ecosystem do not set themselves up for controversy, failure, scams. It will sadden us. This is not that we want to curtail innovation, not at all. As I said, I reiterate, for many months we tried to find a solution. The industry was unable to demonstrate any simulation to justify their claimed returns. We would welcome them to do that.
So, ma'am, first exchanges will...
Shall we move on?
Yeah.
Sorry.
I have a couple of clarifications from this agenda. So, I'll go one by one. If you allow me.
Just take two now, Sajid. I'm trying to speak up.
The first one is on the online bond trading platform. We've been seeing that the specific platforms were created for HNI for trading of bonds and especially highlighted for individual trading on them. Now this will bring in much more clarity in terms of those trading platforms. But we'd like to make available to the public to see how bonds are trading. Or are we going to depend on the exchange platform to see bond trading happening there?
So let's break it up. So the trading and the settlement will happen on the exchange platforms, either on the debt segment or on RFQ. However, the interface for the retail investor will be the online bond platform, where the person who is effectively now going to be a broker and function as a broker will essentially do demand aggregation. That is one model. They may also do an inventory model. They may hold the inventory. Both, and in fact some hybrid models are there. So all models are being permitted. So the interface that the retail investor will have will be to the bond platform, to the online bond platform. At the back, the bond platform will be doing the transactions and settlement, because we cannot have settlement happening anywhere else other than on the clearing corporations. So that the trade and the settlement will happen on the exchange's infrastructure. But the retail investor will not see it.
Ma'am, second question is on the net settlement in F&O and cash. Yes, F&O and cash market. Yesterday, you allowed FPIs to get into commodity derivatives. Have you looked at the opportunity of net settlement across all three, because now exchanges are universal in nature because they have commodities, cash and derivatives. So in that sense,
so at the moment we are not looking at it because the big difference is the question that needs to be addressed is really how we will, in the event of a default, how does the whole settlement guarantee fund get triggered and how does it get utilized. So as you can imagine, the SGF for the commodity side is right now very, very small. Whereas for the other segments of the business, it is quite, of the trading, it is quite large. So at the moment, we think that first of all, the need is restricted to very, very few people. There are very few people who trade across all these asset classes. So the need is also less, and we will need to wait until we assess better in terms of the SGF and how to work that. But at the moment, it's not on the anvil.
Yes, thank you. Hi, ma'am. I have a couple of questions. One, do you think startups will be encouraged to look at overseas listing because after the new stringent disclosure norms, And the second question is around, there were some concerns over regulation by the municipal industry, so bringing MF units under the ambit of insider trading. Do you think that will lead to more sort of a drift between SEBI and the?
So, overseas listing, I can only say that when I was in the private sector, we were of course listed on the Indian bourses, and we also listed on NYSE. And I can only tell you from very personal experience that the extent of disclosure and the extent of due diligence and the extent of legal liability is manifold in an overseas listing. So that's my personal experience. We would be very keen to hear from other people as to what is their experience in terms of benchmarking, and we would be happy to see that if there is, excessive disclosure on our part, we're happy to look at it. But if you really don't want to tell the retail investor what your KPIs are, which you have been sharing with the private equity investors, you really don't want to tell the retail investors, then we need to think about it. If, as I said in a previous speech of mine, 3 months ago you offered your shares at 150, today you offered at 450, and you don't want to make any disclosures about that.
And the second question?
Second question, mutual fund over regulation. What is the proposition? You feel that people, employees, directors and all of mutual funds should be able to do insider trading in mutual fund units, but they should not be subject to regulation. Is that the proposition?
No, I don't have any such proposition.
Acha, okay. Then I think we are clear.
Guys.
Ma'am, good evening. About mutual funds and insider trading regulations, one thing I want to ask you is that a couple of months ago you came up with a consultation paper where when you proposed the inclusion of mutual fund units in the insider trading norms, you included a whole ecosystem of people who would be covered under this. So what's the status on that?
So in that entire list of ecosystem players, there was feedback that we received as part of the public consultation, and that is why we do public consultation, right? We do it with the intention of receiving feedback and seeing whether we missed something or we did something inappropriate, and to then do a course modification. So some of the feedback that came to us in terms of the wider ecosystem was represented as part of the public feedback, and we accepted that feedback, and therefore we modified accordingly. So some elements of the ecosystem are covered, some have been excluded, some have been covered indirectly. So we have modified our proposal in response to the public consultation feedback that we got. Oh yes, it will be, finally when the proposal is actually done, that those details will come.
I want to ask just one more question about so-called allegations about access mutual fund.
I'll never talk about specific cases.
But
I will never talk about specific cases.
राजेश दो सवाल हैं. एक सवाल ये है कि रिसेंट सुप्रीम कोर्ट ऑर्डर्स जो आए हैं, जो आपने चैलेंज किए हैं, सैट ऑर्डर चैलेंज, दोनों ही इन्वेस्टिगेशन से जुड़े हुए हैं, और दोनों में जो ऑर्डर थे सुप्रीम कोर्ट के, वो ऐसा लगता है कि शायद अगेंस्ट है सेबी के अब तक की जो भी बातें थी उन्होंने इन्वेस्टिगेशन किया था. तो पूरा इन्वेस्टिगेशन का पूरा मैकेनिज्म है, क्या आपको लगता है उसको नए सिरे से आपको देखना पड़ेगा कि वहाँ पर क्या ऑर्डर फेल नहीं है? पहला सवाल. दूसरा सवाल ये था मैम, अल्टीमेट बेनिफिशियल ओनरशिप के लिए कुछ ऐसी बात हो रही थी कि थ्रेशोल्ड को कम किया जाए, तो वो चर्चा कहाँ तक पहुँची है, क्या कोई कंक्लूजन है?
सो पहली बात तो मैं ये कहूँगी कि सुप्रीम कोर्ट, ऑनरेबल सुप्रीम कोर्ट जो भी ऑर्डर देते हैं हम उसका नेचुरली पूरे हद तक रिस्पेक्ट करते हैं, और वो हमारी कंट्री का केस लॉ बन जाता है. तो उसके तहत हमें पूरी अपनी इंट्रोस्पेक्शन करनी है, और हम कर रहे हैं कि जो ऑर्डर्स आए हैं उनकी इंटरप्रिटेशन हम किस तरह से समझ रहे हैं, और जैसे कि आपने कहा कि ये इन्वेस्टिगेशन से शुरू होती है, फिर ऑर्डर पे जाती है, फिर अपील पे जाती है, तो वो पूरा जो प्रोसेस है वो हमें रिव्यू करना पड़ेगा, और ना ही अपनी इन्वेस्टिगेशन और ऑर्डर पासिंग का मैकेनिज्म रिव्यू करना पड़ेगा, हमारा जो लेजिस्लेशन भी है उसे भी शायद रिव्यू करना पड़ेगा, क्योंकि वो लेजिस्लेशन जो है 20-25 साल पहले लिखा गया था, और उस टाइम पे आज का दौर जो है, जो चैनल्स है लोगों के कम्युनिकेशन चैनल्स वगैरह, वो सब कुछ नहीं था। वो तो उस टाइम पे हम इमेजिन भी नहीं कर सकते थे कि टेलीग्राम नाम की कोई चीज़ होती है। वो तो टेलीग्राम नंबर 42 हैप्पी बर्थडे टू यू, पर आजकल तो टेलीग्राम कुछ और ही होता है। सो हमारी जो रेगुलेशन है हमें उसे भी रिव्यू करना पड़ेगा, क्योंकि एज आई सेड सुप्रीम कोर्ट का जो ऑर्डर होता है वो हमारे लिए केस लॉ होता है, इट इज़ द लॉ ऑफ द लैंड, हम उसको पूरी तरह से रिस्पेक्ट करते हैं। सो हम अपने प्रोसेसेस भी रिव्यू कर रहे हैं और अपना लेजिस्लेशन भी रिव्यू कर रहे हैं।
सेकंड क्वेश्चन मैम, अल्टीमेट बेनिफिशियल ओनरशिप।
सो इसमें डिस्कशन हुई है, हो रही है, और जो मुद्दा है इसमें कि जो बेनिफिशियल ओनर है वो किस रेगुलेशन के तहत आता है, तो वो जो रेगुलेशन है वो FATF ग्लोबल FATF ट्रीटी के तहत आता है, फिर हमारे PMLA रेगुलेशन में आता है, फिर सेबी के अंदर आता है। सो ये जो अगर कुछ भी इसमें चेंज या रिव्यू या थॉट प्रोसेस होना है तो वो वहाँ से फ्लो होके आता है। तो ये इतनी आसान बात नहीं है कि हमने कल सोच लिया और परसों कर दिया। सो ये सोचने वाली बात है और ये ग्लोबल स्टैंडर्ड्स वाली बात है, FATF से रिलेशन रखती है।
Good evening, ma'am. I just wanted to quickly check. You had mentioned recently about enhanced disclosure norms in the F&O market. Could you flesh it out for us? Any details on what the thought process is within that?
I think this one we'll just need to wait. You won't have to wait very long. तो इसमें वेट कर लेते हैं। रिटेल इन्वेस्टर जो है उसको किस तरह की इंफॉर्मेशन दी जानी चाहिए, under which he is better informed before he is actually trading in F&O. That is the thought process. Obviously, in this case, it's more related to the asset class. It is not a specific, like in IPOs and all, it is a specific company, right? Normally, and under our ongoing disclosures, it's about a specific company. In a mutual fund, it's about a particular scheme. Here, it is about the entire asset class. So naturally, we cannot draw any parallel from the other places. So we are still thinking through how this is to be done. But it will be in the nature of giving the investor at an appropriate time and place the necessary information that he needs to decide in terms of what he wants to do in respect of this asset class.
Ma'am, my question is also a bit related to this, and it's also about how retail participation has been significantly increasing in the equity market, and most of them, they are getting this stock tips and trading tips from sources which are not necessarily SEBI registered analysts or investment advisors. So there was a proposal that SEBI had come up like in 2017, wherein it was going to mention specifically that who can provide stock trading tips via social media, but ultimately nothing came on it. So what I wanted to understand is that now that retail participation is growing, are you looking at any new policy on this, that who exactly can provide such trading tips if they are not registered with SEBI?
So, this is a complicated issue because the spectrum is right from you telling your mother which stocks you think she should buy or not buy, right? It starts from there, right? To somebody saying freedom of speech and somebody saying I'm only expressing my views. It covers the whole spectrum from there. We are currently in discussion with the Association of Investment Advisors and other stakeholders we have shared with them that we are open and willing to a segmented approach. Like I said earlier, if we try and do a one size fits all, it rarely works, and particularly in today's environment. So we are open to a segmented approach on this. So there are different kinds of investment advisors. There are some who only give stock tips, as you said. There are many unregistered who anyway give stock tips. And there are others who do full-fledged investment advisory, investment planning, etc. So I think that it's early days yet. Given the complex nature of this issue, it is early days yet. We are in very active discussion with the industry and the various stakeholders, but it will take us some time. We don't yet have visibility on an easy solution where we say, "Ha, ye idea acha hai, now let's implement." We are not yet there because it's, as I said, the spectrum is so wide.
Even the gap between the number of retail investors have grown significantly, but the number of registered investment analysts or research analysts, if you see, that is registered, it's like huge gap. So, is there any, are you looking at any means in terms of attracting more investment advisors to get registered with Sebi? Because some of them have complained that it's very cumbersome for them to get registered, and that's why they are not doing it.
So that's why they're carrying on doing activity without registration.
Yes. Are you looking at any means that will attract more advisors to get registered with them?
As I said, this is all under discussion right now and it's early days.
Janki?
How long is this reflecting thing for? How long will it be there? And how will you ensure that this information is not leaked? Because we all know how leaky the stock exchange is.
In terms of time periods, I don't.
30 days.
30 days?
Couldn't get the question.
No, she's saying
Pre-filing.
pre-filing document. How long will it be there?
Maybe for 30 days. 30 days.
Companies Act, if you file any the prospectus, you have to file with ROC as well. So while you may be keeping it confidential, it will be available on the ROC's website.
No, it doesn't require to go to ROC at that stage.
won't be
It will go to ROC only at the final stage.
That section says prospectus. It is not a it will become prospectus after it is approved. No?
Investment bankers
It is a
who are
draft.
involved in the process.
Yes.
Yeah.
So I mean that's again.
No. So when I say confidential, it is confidential vis-a-vis the public, and as I said, the main concern expressed was competitors. So I really am not sure how to answer the question of what if it leaks. If it leaks, we'll have to take action. Because this is meant to be held in confidence, whether by Sebi officials or whether by the exchanges. So if it leaks, we'll have to take action. It's meant to be confidential.
Against stock exchanges.
Why not? It depends where it is determined where the leak comes from.
And how long is this pre-filing period?
Yeah, it will be 30 days from the last satisfactory reply. Any questions, your query is read by same.
From the, sorry,
Well,
from the
I-
last.
Last reply that we received from the issuer, satisfying all the queries, 30 days from that.
Yeah, I think she was worried that, SEBI has a very poor record in taking stock exchanges to task when information is leaked or when some scam happens. I think that's what the question was. Anyway, so, most legal firms who are dealing in SEBI cases are very worried after a recent order of Supreme Court involving Kavi Arora case. So what has happened is, there is a feeling that SEBI has been cherry picking on sharing documents with regard to, when adjudication is there and, parties want documents based on which SEBI has come to certain conclusion. And there was another case involving Reliance, wherein the court has said that, SEBI cannot do that. But none of the orders overrule each other. So the ball is completely in SEBI's court and, it can do as it pleases. I mean, there's no standard procedure here as to what documents can be shared or,
how SEBI reaches a certain conclusion. I mean, if parties don't get that, then how are they going to defend themselves? So don't you think there's a grave requirement of standard procedures there on what documents will you be sharing with them, and why not I mean be very transparent and say this is the document, this is our report, this is what we found, and you can have it, and you can go through it. This is how we have arrived at this conclusion. So what is SEBI's issue in sharing all the documents with the parties? Why is SEBI so reluctant in that?
So I will only say one thing, which is that I've said before that Supreme Court orders are the law of the land. So SEBI will follow what the Honorable Supreme Court has said. Now, if there are multiple orders saying slightly different things, it is largely on account of the case facts being different and the circumstances being different. And therefore, we will need to apply that judgment in terms of saying that is this case which is before us more resembling X case or Y case or Z case, and we need to follow the Supreme Court orders in toto. It's as simple as that. So for us, there's no double guessing that, and we will ensure that we follow that. But there are differences
in sharing, in sharing the documents that make you reach that made you reach the conclusion.
So that's the question. See, if you see the words you have used, what is the harm in sharing documents that have made you reach that conclusion, right? Right? Which have made you reach that conclusion, right? Which means what? What is it that you have relied upon? Right? That's what, if I rephrase what you said, it is what is it that you have relied upon? So there is a lot of case law in this. I think this is not the forum for us to analyze case law. So there's one simple thing that SEBI follows, that whatever has been laid down in the courts is the law of the land, and we will follow it. That's all.
Hi, ma'am. Pushpati from Business Standard. I've already asked the people on the pre-filing of offer document. It mentions that there is an optional alternative mechanism. What if more companies go towards this as a mainstream method? Is there any catch from the SEBI side that this company is not an optional and more companies go towards this optional route? And
they are free to. See, it's really, for, as I said, it is a liberalization measure. We're just giving two roads. So you want to go from here to Agra, do you want to go via Lucknow or you want to go via Ahmedabad? It's up to you. So we are perfectly agnostic. Wherever the market would like to take this, we are happy and comfortable.
And one question on the OFS mechanism that has been relaxed upon. Do you think this could lead to some the block deals becoming less popular just because the duration is around 2 weeks or in the reduced to 2 weeks? Do you think block deals will become less popular after this?
So would they have far more flexibility in this mechanism? Yes. Because under the block deal mechanism, as you know, there is a restriction on the price, right? It's plus minus 1% of the price. Whereas here, the offer for sale can be done at whatever price you like, and it's open to the market. So they have far more flexibility. So if they have far more flexibility and they wish to come through this route, we are very happy. So again, it's a question of giving flexibility to the market. And there's nothing really constraining them, right? Other than you need 25 crores. So obviously it's for the larger shareholders. We are very happy for them to take this route or that route. That window has a cap of price. This one does not. If you are happier here, no problem.
Ma'am, hi, good evening. You have mentioned in the KPI proposal that committee of independent directors should recommend the price band and justify it with quantitative factors. Most of the time, all the independent directors are not qualified to justify the price band because they come from different backgrounds. So, what is the rationale for that? This proposal?
So see, we believe that if the independent directors have been placed there, they have been placed there because they are people of competence and stature and that they deserve to be there. The second thing is that they have and can call upon any resources that they feel they would like. So if they need to call upon the auditor or the CFO or somebody else, they are always free to call upon, while arriving at their judgment, they are always free to call upon whatever resources and specialists that they need. The merchant banker, the valuation firm, they can call upon all those people to get them to explain to them what is the rationale behind the pricing, etc. And they can then take a informed decision. So I think it is important, and if we are of the belief that the retail investor can use the information and make an informed decision about the price of the shares, surely the board members who are put there would be able to exercise that judgment as well in advance. So we have no reservations on that count, and they have, the whatever resources they need at their disposal to do that.
Yes, please.
Good evening, ma'am. Anurag Joshi, ET Now Swadesh. My question is on the inclusion of trading of units of mutual funds in the insider trading regulations. What framework is Sebi looking or considering to set up to monitor on an ongoing basis instances of insider trading in units of mutual funds?
So we have various algorithms that we have developed for monitoring insider trading in shares. Those algos need to be suitably modified to be able to apply for mutual funds as well. The important thing is to be ingesting all of that data, because that data currently is with the RTAs, right? It's not with the exchanges. Some is, if it's on the exchange platforms, then it is there, but the source of truth for all of that is the RTAs. So that data needs to be ingested, and it needs to be subject to the same algorithms, albeit modified for the purpose of mutual funds, and that is the way in which we will proceed. The definition and the illustrative items of material price sensitive information, also an attempt has been made to give an illustrative list in the circular. So that would be the starting point of all identification, that if an event has happened, then before and after that, was there somebody who seems to have done some exceptionally lucky trades and fortunate trades. So those would be the ones that would need to be examined further. So like we do surveillance in the stock market, we would start doing the surveillance in mutual funds.
They have to frame internal framework for prevention of insider trading, just like
The way companies have it.
yeah. All mutual funds, they have to frame internal guidelines for prevention of insider trading. Just like in a listed company,
Code of conduct.
there is a close out period, open period, when they can trade. So similar thing they have to put it. Suppose someone wants to trade when there is a confidential information is there in the scheme of the fund, then they have to take a pre-clearance and all. Those framework will be there.
Chairperson ma'am, two questions. One, as far as PSC is concerned, we don't have an MDCA. The proposal happens to be with
We
Sebi
won't
for
talk
here.
about specific companies.
Okay. Another question I wanted to understand, absolutely hypothetical situation, but in a situation where an entity which is a shareholder in a company, where the promoters are barred from the securities market for whatever reason, can that entity convert its...
We will not talk about specific cases.
Can stock exchanges or commodity exchanges run without vendor support to technology?
We will not talk about specific cases.
First level regulators running without technology.
That's all right. We will not talk about specific cases. Let's move on.
Two questions. One, in this issue of new economy company where more disclosures are required.
No, this is true for all.
Yeah.
This disclosure requirement is for all IPOs.
Yeah. My question is with respect to the secondary transaction to the promoters buying and selling, or is it all investors?
Any secondary transaction.
So,
For instance, you may have had a secondary sale from one private equity to another. That would also be a transaction because it establishes a price.
That's a clarification I wanted. The second one is with respect to takeover for PSUs. They've done away with 60-day requirement. Normally we see there's a run-up in stock of PSUs, as we said, because of speculative activity. Is the regulator also looking at bringing in delivery pays or T2T for those companies which are going for divestment? Purposes like similar to what we have done in the case of NCLT companies where they immediately go into T2T to prevent the speculative trading.
We have not even considered such a thing.
There will be dealt with as per the GSM mechanism already in place.
So,
in case of
question is
large
that,
scale
if
volatility.
a listed company is going for divestment and the price much significantly lower than the current market price, the retail investor who is bought into that company will be at a loss because of speculative trading which has come.
So we've not thought about this. We've not entertained this thought at all in our mind. So we can't tell you what is our thinking on it. Maybe we should examine. Maybe we'll examine, but we've not thought about it yet.
And on the pre-IPO filing one, you said observations will be shared with the public in case we are going for the pre-IPO filing route, right? Why isn't observations shared in the current IPO mechanism? We just get to know, okay, the observation has been done, but and the disclosure
it is there.
What exactly is that
No.
you're asking?
No. It's not different. It's just the time period. So, because right now what happens is the detailed document is first made public. In parallel, Sebi processes. So, when Sebi gives its observations and they have to be incorporated in the document, after that only 5 days it is in public domain. Whereas now what will happen is, since all Sebi observations are already baked into the document that has gone public, it will be available for 21 days with all the Sebi observations baked in. So that's the difference.
Now only RHP stage only public come to know. The complete document with Sebi's observations and also incorporating the public comments whatever, it only comes to the knowledge of the public only at the time of filing RHP, which remains in public knowledge for 3 to 5 days. Prior to this.
Ma'am, I have a question on concept of directors not liable to retire. Is SEBI comfortable with this?
Sorry, I didn't hear.
This concept of directors not liable to retire.
Not liable to retire.
As in, and AOAs allow them to be on the board perpetually. So,
Directors not being allowed to retire.
No, there is a Companies Act restriction, no? 75 years, something.
Independent service beyond that.
no, for instance, if there are certain directors who cannot be removed from the board because AOAs allow them to be permanently on
Sorry,
the
who allows?
The articles
Articles of association. Okay.
So, is SEBI comfortable with this arrangement?
I must say we have not examined this matter, so can't say right now.
It is referring
But
to
my
particular
understanding is that perpetual is anyway not, because there is an age limitation. So age limitation anyway kicks in. Now whether there is any other limitation, we have not examined the matter.
Ma'am, are you looking at mandating KFPs or mutual funds to disclose?
Yes, we
other
can.
investment
Others also ask.
When this disclosures of KPI.
Sorry, please, we will come back. That's not.
Yeah, Anirudh, please.
Just a quick clarification, ma'am. On the KPI bit, in the consultation paper, it had specifically mentioned new age tech companies. I just want to understand, you said now that it's applicable for all, so even a traditional profit-making company has to disclose similar KPIs apart from financial metrics.
Yes.
Yeah.
Because the line between the two can be very blurred. So we don't want any ambiguity. Someone will say, no, I am not a new age tech company. Someone will say, I am not loss making. Why? Because I made 5 rupees of profit last year. So, we don't want ambiguity in this, and we don't want unnecessary, as I said, lack of clarity. So this is a rule, financial ratios, KPIs, disclose everything.
Sorry, we'll come back. Please follow.
On this only, this is a clarification when this will be applicable.
When the regulations are notified.
मैम एक सवाल कम्युनिटी मार्केट के लिए इस बात की चर्चा हो रही थी और कुछ रिकमेंडेशन दी थी इस तरह की कि जो काफ़ी सारी कमोडिटीज जिन पर दूसरा सवाल ये है कि मैडम कि बहुत सारे ब्रोकर्स ने क्लाइंट से अपफ्रंट मार्जिन का जो कलेक्शन नहीं लिया था, उन्होंने ब्रोकर्स ने क्लाइंट को पास कर दिया था, लेकिन एक्सचेंज के सर्कुलर के बाद भी ब्रोकर्स रिफंड नहीं कर रहे वो अमाउंट जो क्लाइंट से बतौर पेनल्टी लिया था। तो इस पर क्या कुछ करने की सोच रहे हैं?
सो पहले कमोडिटीज़ के बारे में, जैसे कि आप जानते हैं कि ये जो मुद्दा है ये सेबी और जो सरकार है वो एक साथ डिसीजन लेते हैं और इसके बहुत वाइड रेपरकशंस होते हैं। तो अभी जो फ़िलहाल कुछ कमोडिटीज़ हटाई गई हैं मार्केट से, तो सही यही होगा कि उसका जो असर है, निकालने का जो असर है, उसको पहले स्टडी किया जाए कि क्या हुआ एक्चुअली, प्री बैन, पोस्ट बैन, व्हाट वाज द इम्प्लीकेशन, और वो जो पूरी स्टडी है उसको ठीक से एनालाइज करने के बाद ही कुछ आगे चर्चा होनी चाहिए और कुछ डिसीजन लिया जाना चाहिए। सो अभी इट इज स्टिल अर्ली डेज फॉर दैट टू बी डिसाइडेड। On the second point of penalty, हमारे यहाँ कुछ कंप्लेंट्स आई हैं कि ब्रोकर्स ने इन्वेस्टर्स से कलेक्ट किया है पेनल्टी, हालांकि सर्कुलर बहुत क्लियर है कि ये इन्वेस्टर्स से नहीं कलेक्ट किया जाना चाहिए। ये जो है कंप्लायंस की तरफ से एक असेसमेंट हो रहा है एक्सचेंजेस में, सेबी में, और उस पे डेटा आने के बाद हम लोग चर्चा करेंगे कि इसका क्या किया जाना चाहिए और क्या वजह है, क्योंकि हम हमेशा यही कहते हैं कि हम रूट कॉज एनालिसिस पे जाएंगे कि ये हुआ क्यों, सो किसकी गलती है। तो इस तरह से वो जो भी जांच होगी वो डेटा देखने के बाद और पूरा रूट कॉज एनालिसिस करने के बाद ही कुछ उसमें डिसीजन लिया जाएगा। लेकिन ये कहना आपका बिल्कुल सही है कि रूल बहुत क्लियर है कि अगर वो शॉर्ट मार्जिन कलेक्शन है तो वो ब्रोकर की रिस्पॉन्सिबिलिटी थी और उसको पेनल्टी देनी चाहिए। सो इस कॉन्टेक्स्ट में जब डेटा आएगा तो हम उसको एनालाइज करेंगे।
मैम, किसी केस स्पेसिफिक नहीं पूछना चाहता हूँ, लेकिन कई बार हमने देखा है जो कंपनीज आईबीसी रेजोल्यूशन में गई हैं, आपने पहले देखा होगा, वहाँ पर रेजोल्यूशन प्लान में होता है कि या तो डीलिस्ट करा दिया जाएगा या 100 शेयर का 1 शेयर कर दिया जाएगा। वहाँ पर क्या कोई एडिशनल डिस्क्लोजर करने पर सेबी विचार कर रहा है? दूसरा, क्या उन कंपनी को डिलिस्ट हो जाना चाहिए, इस पर कोई विचार है? मैं आपको भी बताना चाहता हूँ।
हमें ऐसा लगता है कि ये थोड़ा पेचीदा मामला है, क्योंकि देखिए जब कोई कंपनी, पहले तो 2 टाइप ऑफ कंपनीज होती हैं आईबीसी में। एक तो जो लिक्विडेशन में जाती हैं, तो वहाँ तो बात ही ख़त्म हो गई, वो कंपनी ख़त्म हो गई तो शेयर होल्डर भी उसके साथ, एनीवे द शेयर होल्डर इज द लास्ट, राइट, हैज द लीस्ट राइट्स, दैट्स व्हाई यू आर एन इक्विटी शेयर होल्डर। सो एज फार एज लिक्विडेशन कंपनीज आर कंसर्न, देयर इज नथिंग टू डिस्कस. As far as the companies which are going further, which are surviving, again, like you said, there are the ones who are going for delisting and there are the ones who are continuing. Now, currently there is a regulation and a formulation on who is eligible to delist and how will that process work. Based on the learnings of the past few cases, we are in discussion with IBBI to see whether this process can be improved in any way. But again, it is very early days. We are still learning, we are still collating data, we are still trying to understand, and it will take time. It is early days.
One very quick question. Are you looking at mandating AMPs at various mutual funds to also disclose how they invest their money in different schemes, in different funds of different houses? Is that something that you're looking at?
Not that I am aware of. Anything, sir?
No, nothing.
Thank you.
Thank you.
Thank you.
Thank you.
Ma'am, can we sort of discuss how the following press conferences will happen, exactly what we had discussed the last time.
Meaning?
I mean, can we have the press release a little early and then the...
Yeah. You know, normally we are actually, by the way, based on your feedback, we have actually, I don't know if you've noticed, that we now have a certain window within which we do all our uploading of circulars, orders, everything, press release, etc. So we took that feedback very seriously. As I said, today it was difficult because we had such a rich agenda that the board, obviously we had a very long board meeting. So it was not possible to do that, and my apologies, we kept you waiting a long time. But you know, it was a full agenda and we have a lot of work to do. So I cannot promise you that our December board will be any less rich or substantive. So, क्या करें? बहुत काम है करने को.
Can they keep the tea going in the meeting?
Oh yes, Hariharan. Please, चाय और समोसे खत्म नहीं होने चाहिए. Chai and samosa should not finish.
Absolutely. Thank you so much.